Okay, this is the third part of the interview that I did with Jose Silva Jr., an attorney in Vineland, New Jersey. And this section's all about powers of attorney. So, Jose, what is a power of attorney exactly?
A power of attorney is the beginning of your estate plan. And as I said earlier, there are three documents that individuals should have. Potentially, the fourth would be a trust. But to simplify things, you have a power of attorney, and we refer to as a POA, the healthcare directive, and a will. You have to have the mental capacity to enter into a contract in order to have a power of attorney or a healthcare directive or a will. In a power of attorney, you are authorizing someone to be your attorney in fact, and you're giving them authority to act for you on your regard on all of your assets. It could be real estate, it could be financial, banking, it could even be with them obtaining your healthcare records. So you're giving this person carte blanche authority to act for you. I've done power of attorneys, for example, someone has real estate in Puerto Rico and they authorize their mom, their sister, their brother to act on their behalf to transact for that specific purpose, to sell the house, buy a house, close a bank account, whatever it is, but it's limited. There are two different types of power of attorneys, but before we get there, the power of attorney will say, I so-and-so appoint. And I usually have people appoint more than one person. You have the general, the specific person who's your attorney in fact, and then you have alternate attorneys in fact. They all have the authority once the one above them no longer has the authority or rescinds. They don't want to do it. So the example we used earlier was that you appoint Phil Fratto to be your attorney in fact, but Phil Fratto is on his honeymoon. Something happens to you that you cannot conduct your business. So the power of attorney will say, I appoint Phil Fratto, but if he is unwilling or unable, then you appoint somebody else. You could appoint your mom, your dad, your sister, your brother. You can't appoint your dog or your cat, okay? But you can appoint someone who's over the age of 18 to transact your business. Now, what happens if Phil Fratto says, I don't want to do that. I'm too busy. I just got married. I'm, honeymooning. I'm going to Australia. I'm going to Italy. I don't have time to do this. So you're covered because it says if he's unwilling, then that happens. How about if he's unable? He gets into a car accident. He's now in a wheelchair. He can't run around for you. So then you have those alternate individuals. So then you have the attorney, in fact, number two, we call agent number two, and then agent number three. And you can put as many people there as possible that you would trust, the individual would trust, you would know that they are not going to steal from you because they have the authority to take everything. Sell your house, sign deeds, hire lawyers, accountants, go to the bank and just liquidate everything you have. Go to the stock market, transact anything and everything. So if you have something on the market, you have stocks and bonds, you have options, they can go ahead and do all your transactions. They can liquidate them. So you need to know that that person has full authority to do that. Most individuals will just choose their wife or husband first, their spouse, as number one. In the event that spouse is unable, then they choose one of their kids. And they generally don't choose the oldest child. They choose the most level-headed child, the most responsible child to take care of those type of situations. It could be the youngest child who is very responsible and mature over the adult child who's the oldest but has been in prison 25 times. So those type of things can occur.
Okay, so an attorney in fact can act on your behalf, and you can have multiple attorneys in fact lined up. Can you have several different people acting as an attorney in fact?
You can. I don't encourage it. Some attorneys encourage it. I don't, because there could be conflict. And with conflict, things can happen. If you want to have checks and balances, you can do that. But usually you have that in a situation of a will where you appoint, for example, a trustee who is in charge of a trust for a child. And then you have the custodian who's a different individual, and you have the checks and balances. And usually the custodian will tell the trustee, I need $1,000 to pay for Johnny's college education. The trustee will say, I want to see a copy of the registration, the receipt, and all this stuff first before I give you a dime. Or they might make the check payable straight to the university. But if you want to have checks and balances, you can. It makes things a lot more difficult.
The content provided herein in writing, audio, or by video is for informational and educational purposes. The content is not intended as legal advice to the individuals reading, listening, and/or viewing any of the content herein. Each case is different, and as such, by accepting to view, listen, and/or view the content, no attorney-client relationship has been established between Jose Silva Jr. and his law office of Jose Silva Jr. Attorney at Law LLC. Furthermore, the information here is a marketing tool and advertisement by Jose Silva Jr. Attorney at Law LLC and its employees, agents, and representatives. Should you have any questions regarding the content herein and wish a consultation with Jose Silva Jr. Attorney at Law LLC, you must set an appointment for a consultation and pay the required consult fee. At that time, further and perhaps more specific information may be provided as it pertains specifically to individual cases.
Securities and insurance services offered through Royal Alliance Associates Inc., member FINRA SIPC. Insurance services may also be offered through Harbour Master Diversified Financial Services Inc. Advisory services offered through Investment Advisors Asset Management LLC, a registered investment advisor. Royal Alliance Associates Inc. is not affiliated with either entity.